Picking up where we left off, if you violate parole, you'll be sent back to serve either the remainder of your sentence or a part of it until you can be up for parole again. Death penalty, also known as capital punishment. Very controversial topic, obviously. We'll spend some more time talking about it later this school year. Now, to put it as clearly as possible, the convicted is sentenced to death at the hands of the state. The government executes the convict, the individual convicted of the crime. Most states, lethal injection is either the only or is going to be the primary form of execution. Some states still do have electrocution as a form, but in those states, lethal injection is still the primary. And when I say primary, what I mean is that's going to be the one the government uses unless the convicted asks for the secondary method. If the convicted does not make a choice, it defaults to the primary method, which is lethal injection. The gas chamber is still used in a few states as their secondary method. Hanging is still technically on the books in a few states, as well as the firing squad. This is assuming that my stats are still good. I got these last year at about this time. Things do change, though. 21 states have full-on outlawed capital punishment, such as Colorado. And then there's also a number of states who will have a moratorium on it. That's what we see here in the purple in Pennsylvania, is that we have it, we're allowed to use it, but we don't use it. That the government has said, we're going to not use this for a while. I believe there's an instance a few years ago where Governor Wolf had, there was the potential of somebody going to be put to death in Lancaster, and Governor Wolf said flat out that if you follow through with this, I will use my executive powers to reduce his sentence so that he will have life without parole. So, as I said earlier, most states require that second trial, a death penalty trial. The person's already convicted. We know that. They have been found guilty. Now it's to determine what sentence should they receive, whether it's death, life without parole, or life with a possibility of parole, or even potentially a number of years, fewer than life. This jury has to be what's called death qualified, in that they aren't absolutely against the death penalty, but they're also not of the mind that it should always be used or that it has to be used. A death qualified jury should be open to the possibility of it. And death qualification, though, does have its own criticism, that it creates a bias, the idea that the possibility that people are more likely to find the defendant guilty, knowing that they don't have to give the death penalty. It's an argument that if the death penalty was more likely to be used, or if the jury was more likely to use it, then the jury may be more likely to find the defendant not guilty. Like I said, it's not without criticism. Now, here's an interesting case, Roper v. Simmons. This was decided by the Supreme Court in 2005. A young man, Christopher Simmons, was sentenced to death at 17, or for a crime he committed at 17 as a minor. He appealed his case. As you may be aware, the appeals process for a death penalty case takes a long time. You don't just walk out of the courtroom right to the execution chamber. You have your opportunity to appeal your case. Meanwhile, Atkins v. Virginia by the Supreme Court decided in 2002 that it is in violation of the 8th and 14th Amendments to execute people who are mentally disabled. So then this brought Simmons' case to light, and it was decided that executing minors is a form of cruel and unusual punishment. It is decided that the standards of decency have evolved to the point that this is considered cruel and unusual, and also in what was said by the Supreme Court majority decision, in overwhelming international opinion, that this is cruel and unusual. An example I want to show you real quick is that of the DC snipers. On the left is John Muhammad, a grown man, a legal adult. On the right is Lee Boyd Malvo, the minor, the under 18 young man who assisted in the 17 convicted homicides. About 10 years ago, John Muhammad was executed by the state of Virginia, the Commonwealth of Virginia, as per his sentencing. Lee Boyd Malvo, since he was a minor, even though he was convicted of the same crimes, he was unable to be given the death penalty because this was after Roper v. Simmons. So he was issued life without parole. So he appeals his case, saying that he should have a lesser sentence, that he was brainwashed, he was manipulated, which there's plenty of evidence to that. But he's appealing this case to the Supreme Court, and then meanwhile, the Supreme Court, or not the Supreme Court, the Commonwealth of Virginia, has a change that in the state law makes any person who is sentenced to life as a juvenile and served 20 years could be eligible for early release. So he wound up dropping his request by the Supreme Court. And fun fact, he got married in March while in prison. So that's neat. So anyways, that's what I have for you for this material, guys. Your assignment then, get you back here to this folder, Group B. Read this brief article, Purposes of Punishment. Check out this graph. Then you have some quick questions here. Basically what you're doing is you're telling me what's the best reason for government-imposed punishment and what's the worst reason, and explaining those. And that's what your assignment is. Other than that, I don't have anything else for you. I hope you guys have a great Thanksgiving. Be safe, and I hope I get to see you in person in December. Bye.